All right, here. Hello, everyone. Terrible Ted with America Betrayed here. Wanted to do hopefully a short, quick video here about the upcoming next step in the appellate process for Richard Allen's conviction, which I believe takes place in late September. So, I've had several conversations this week about the case, and of course, I've put way too much time and attention into this, but here's what I did. I went to ChatGPT. I got a little curious about this 3-judge panel that's going to hear these oral arguments coming up in September. And I tried to get a little inside profile on these judges. Let me read through this. You might find this interesting. And I've told my guests, I see no reason to be optimistic about this. If they can railroad you into prison like they did Richard Allen, apparently, why should I be optimistic about that? The idea that this is going to get overturned and reversed. So I asked, who are the 3 judges that will handle the oral arguments in Richard Allen's appellate case in September? Let me zoom in here, make this a little bit bigger for you guys watching. The 3 Indiana Court of Appeals judges assigned to hear Richard Allen's case are Vedic, Brown, and Pyle. The argument is scheduled for 10 a.m. Monday, September 21st in the Indiana Supreme Court courtroom at the State House in Indianapolis. Allen's appellate attorneys will argue before the 3-judge panel. The state will respond and the judges can question both sides. One important point, these 3 judges, not Fran Gull, will decide the Court of Appeals stage of Allen's appeal. They can affirm the convictions, reverse them, order further proceedings / a new trial, depending on the issue, or issue another form of appellate relief. Afterward, either side can seek transfer to the Indiana Supreme Court. If you want, I can also profile Vedic, Brown, and Pyle and their backgrounds, judicial philosophies, and past rulings in criminal appeals to see what this panel might mean for Allen. And I responded back to the AI and I said, let's analyze and see if they're going to deal with this honestly, which would be prioritizing Allen's constitutional rights, which a few were violated, or if they're going to lean towards protecting the image of the Indiana judicial system and rule that the appeal is a nothing burger. So you see, I'm trying to use AI. I'm trying to get a profile. I don't know these people, and they're small, they're state judges. This isn't a federal thing. So I don't know if I Google their names if I'm going to find much of anything. You know what I mean? So it responds back to me, yes, but first I need to correct something from my last answer. I gave you the wrong 3rd judge. The panel currently reported for Richard Allen's September 21st oral argument is Nancy Vedic, Elaine Brown, and Robert Altus Jr., not Rudolph Pyle. WRTV reports the argument is set for 10 a.m. Yeah, we know that. Okay. The correction actually makes the panel more interesting. How I'd assess this panel. I would not assume these judges are going to rubber stamp Judge Gull simply to protect Indiana's judiciary. There is evidence, especially with Altis, that this panel is capable of ruling against trial courts and the state when legal rights have been infringed. But Allen faces the normal structure difficulty of any criminal appeal. Appellate courts give trial judges substantial discretion on evidentiary and procedural rulings, and many errors can be deemed harmless even when the appellate court agrees an error occurred. Nancy Vedic is the most institutionally senior figure of the 3. She is a former prosecutor and former trial judge, has served on the Court of Appeals for decades, and previously served 6 years as chief judge. That background tells me she understands both prosecutorial decision-making and the practical authority of trial judges. I would expect her questions to focus heavily on standards of review. Even assuming Gull was wrong, why does that require reversal? That distinction could become crucial. Elaine Brown is similarly experienced more than 15 years as a trial judge before joining the Court of Appeals in 2008. Her long trial court background could cut either way. It may make her deferential to Gold's courtroom management decisions, but it also means she knows what ordinary trial procedure looks like and can recognize when restrictions materially interfere with the defendant's ability to present a defense. Robert Altice may be the most interesting judge for Allen. He himself, a trial judge, and later became chief judge of the Court of Appeals. More importantly, there is concrete evidence that he is willing to join opinions enforcing defendants' constitutional rights against the state. For example, in Hogg v. State from 2024, Altice concurred in reversing a trial court after prosecutors added 5 new charges following the defendant's successful appeal. The opinion emphasized that courts have authority to dismiss charges when prosecution would violate constitutional rights, and ultimately held that the trial court abused its discretion. That doesn't predict how he will vote in Allen, but it undermines the idea that this is necessarily a panel of judges unwilling to disturb a criminal prosecution. The real danger to Allen isn't necessarily nothing happened. It's something subtler. More subtle? Subtler? Subtle. Quote, errors occurred, but none individually or cumulatively deprived Allen of a fair trial, and any error was harmless in light of the evidence. This is the path I would watch for. Allen doesn't merely need to convince them that Judge Gold made questionable decisions. His lawyers generally need to overcome the applicable standard of review and, where required, show prejudice, that the error affected his substantial rights or the fairness/reliability of the proceeding. So I would mentally divide the appeal like this. The issue of third-party Odinism evidence excluded. What Allen needs the panel to see is not merely weak alternative suspect evidence, but evidence sufficiently connected to the crime that excluding it prevented Allen from presenting a meaningful defense. Another issue, the Brad Weber/White Van timeline. What Allen needs the panel to see is whether the state was permitted to present a materially changed account, and whether the defense had a fair opportunity to challenge it. On the issue of confessions that were made while incarcerated, Allen needs the panel to see whether circumstances surrounding Allen's mental/physical condition, treatment, medications, confinement, and reliability were adequately presented to the jury. On the issue of the prison treatment/the 13-month confinement, Allen needs the panel to see whether this bears legally on voluntariness/reliability rather than merely making the state look bad. On the issue of the ballistics and the unspent cartridge, Allen needs the panel to see whether admission and presentation of the firearm/tool mark evidence crossed an evidentiary reliability line. On the issue of defense restrictions, Allen needs the panel to see whether Gold's rulings, viewed together, deprived Allen of his constitutional right to present a complete defense. On the issue of cumulative error, Allen's team needs the court to see, even if no single ruling warrants reversal, whether the combined effect made the trial fundamentally unfair. Excuse me. Okay, moving on. The complete defense issue is potentially much more powerful than simply saying the Odin theory should have been admitted. The constitutional framing is this. The jury heard the state's theory explaining who committed the murders and why the evidence pointed toward Allen, but the defense was prevented from presenting significant evidence supporting its competing explanation. If Allen's lawyers can establish that the excluded evidence met Indiana's evidentiary requirements and had sufficient nexus to the murders, that becomes a serious 6th and 14th Amendment question rather than merely disagreement over Judge Gold's evidentiary calls. One thing that gives me some confidence in the process: The Court of Appeals itself explains that its 3-judge panel exists specifically to provide review of a single trial judge's decision, and cases are assigned through the court's panel assignment system rather than assembling a special panel for a particular desired outcome. Also, granting oral argument matters. It does not mean Allen is likely to win, but the judges could have decided the appeal entirely from the briefs. Giving counsel a live oral argument provides an opportunity for the panel to probe exactly where they see weakness. Well, yes, this oral argument, they need to have someone who's quick-witted and able to argue on their feet, not necessarily draft the best paperwork here. And I hope they have that. I've got some questions about who's going to be on this thing and who's going to be steering the ship. Should Baldwin and Rosie and Jennifer Auger, should they be steering the ship if they failed the first time? I don't know. The question on September 21st. I'm sorry, did I skip a line? Giving counsel a live oral argument provides an opportunity for the panel to probe exactly where they see weaknesses. The questions on September 21st may therefore tell us far more than the judges' biographies. I'd listen particularly for questions like this. Counsel, even assuming the trial court abused its discretion, where is the prejudice? That would suggest concern about harmless error and potentially affirmance versus how could the defendant present a complete defense if this evidence was excluded? That would be considerably more encouraging for Allen. Or to the state, what limiting principle would prevent a trial court from excluding virtually any third-party culpability evidence under your position? That's a very good sign for Allen. And perhaps the biggest one is, are you asking us to find this error harmless? If the judges start forcing the state to defend harmlessness, it can indicate they've already moved mentally past whether an error occurred and are considering whether that error requires reversal. My preliminary read, I would not characterize this as an obviously hostile panel for Allen. Vedic and Brown are deeply embedded, experienced Indiana appellate judges, so I would expect considerable respect for the precedent, standards of review, and trial court discretion, not a wholesale retrial of Gold's decisions. Altice, however, has demonstrably joined decisions reversing trial courts where constitutional fairness required intervention. The biggest risk is probably not a decision saying Gold did everything perfectly. It is an opinion saying Gold may have erred here and there, but Allen received a constitutionally adequate trial. The evidence of guilt was sufficient and any errors were harmless. That's the legal route by which an appellate court could affirm without explicitly endorsing every controversial thing that happened. The defense's best counter is to make the judges see the case cumulatively. Cannot exclude major portions of the alternate suspect defense, restrict attacks on crucial state evidence, allow disputed forensic evidence and changed witness testimony, then evaluate each ruling in isolation and conclude none mattered. That's where I think the September oral argument could become fascinating. And that is the end of it. So I happened to, have a few conversations this past week. And one of them, which I'll be releasing in the coming days, is a session that I had with Rick Snay. And Rick Snay was, boldly confident that things are going to go the way that they want for Allen's defense team come September. So I don't know. I need to study this more. But there you go. There's the inside of baseball, something that crossed my mind. And I hope you enjoyed the video. Go ahead, like, subscribe if you're not subscribed, share the video. Terrible Ted signing off. See you next time, guys. Thanks.